about the most important part of the contract, that is about the contingent contract itself. And before proceeding to that, we would like to have a brief discussion from section 26 onwards, which we have already discussed in the last class. We have already discussed about the agreement in restraint of the trade, agreement in restraint of the marriage, and agreement in restraint of the legal proceedings. Okay. So besides this kind of the contract, we have also studied like what is the what are the other clauses of the arbitration which makes the contract available or allowed. Okay. And we have also discussed agreement in the due to the void or uncertainty. Okay. So at first, coming to the part of the section 26, we need to understand that agreement in restraint of the trade or agreement in restraint of the marriage, that is totally void in nature. Okay. So when I'm talking to you about the nature of the contract, which we can say that is the agreement in restraint of the marriage is void in nature, then what do we understand? Okay. Any kind of the agreement which is restraining or which is restrained by any conditions of the marriage, that kind of the agreement is void in nature. That we have already discussed. Okay. And agreement in restraint of the trade, on which we have already discussed under the Indian Constitution, we have the right to freedom and we have the specific fundamental right to enjoy our life, of the right to life and personal liberty under Article 21 of the India. And under that, we have already discussed that every person has the legal right to carry forward his or her business at any part of the India. That means if I am a person who is carrying any kind of the trade at any part of the India, then I have my right to expand my business. I have my right to expand my profession, and most importantly, I have my right to carry forward any kind of the trade agreements which I want to. Okay. And coming to the conclusive point, as we have already discussed in the last class, where any kind of the agreement or contract that is restraining me, that is just opposing me from carrying any kind of the contract, and if that is harming my reputation, my trade, my business or per se, then those kind of the contract is void in nature. For example, I have been, if I want to buy a house or if I want to buy a land, and in return, I have to sign certain agreement that I am not allowed to sell that land further. Or for example, I have been restrained by certain agreement terms and conditions that I am not allowed to carry any utensils business, carry any particular type of business which I am already carrying or I want to pursue. I have been restrained to continue that kind of trade. And in that condition only, I will be given that, but I'll be sold that particular house or particular land. So in these conditions, if any kind of the trade or business, in that condition, if any kind of the trade or business that is being restricted by a particular person or by a particular company, then that specific agreement or specific contract is totally void in nature. Got it? Then we have understood about the exception related to this, under which I have already told you, if someone is an employee of a particular company, and if that person as an employee signs a contract with the employer that he or she is not allowed to carry the similar business, then that is a valid contract. For example, I am working in a company as an employee where the company is producing the vehicle instruments, right? The parts of the vehicles. Okay, so I am at a managerial position or at a chief position where I have been authorized to handle all over the cases, to handle all over the data, how the machines are being produced, how they are being utilized, everything. I have a very detailed knowledge, a very vast knowledge related to that. Okay, so what happens when I am continuing my employment or whenever I am working as an employee, in that period, using my knowledge which I have gained during my working period, what I am doing, I am opening another company during the period of my employment and selling the same kind of the utensils of the vehicles. So here, this activity of mine is totally illegal and unauthentic in nature because this is the breach of the trust towards the company. Here, the company is trusting me. The company is carrying business with me. Yes or no? I am being the part of the company and I am handling my customers. So what is happening at a consequence when I have been carrying another kind of business, or when I am pursuing the similar kind of business on which I have already expertise due to the working period of the company, then what happens that the particular company where I am working, that company is going to be affected because of my new company or my new products or my reputation. People are going to be misguided that the products I am selling that belongs to the particular company where I have been employed. So here the loss of the company is totally valid, and if in that case the employee is signing any kind of the contract with the employer that during the period of the employment the employee is not allowed to carry similar kind of trade or business according to that contract, then those kind of contract is totally valid in nature. Okay, so under section 28, we have already understood agreement in restraint of the legal proceeding is void is totally void in nature. So when we're talking about the agreement in restraint of the legal proceeding, that exactly speaks that if any kind of the agreements or contracts that is restraining or prohibiting the legal agreements, the legal contracts, the legal proceedings, in that case, those kind of agreement are totally void in nature. Okay. Upon that circumstances, we have already understood that, for example, in a certain type of company agreement, I am working in a company as an employee. Okay, मान लीजिए. So what is happening that during the course of my employment or during my work period of my employment, I have been contracted or agreed upon a condition before my employment period. I had to sign a certain agreement paper with the company and me. There is an agreement between both of us, right? So when I'm signing that contractual paper, I have never marked that, but there is a clause, it has been, which has clearly written that even if the company is doing any illegal activity against me, or even if company is doing any kind of the activity which is not legal or valid in nature, I don't have right to raise my legal concern against this. I have no right to go to the court of law, or I don't have right to create any kind of the legal complaint against the company or against my employer. So here that kind of clause of that agreement is totally void in nature, because any kind of the agreement which is restraining the legal proceedings, which is restraining the legal implicability or the legal uh, enforcement or the legal authority of a particular person, those kind of the contract or agreement is totally void in nature. Clear? Then we have already understood the exceptions related to this. The exception one, we have understood that saving of contract refer to the arbitration dispute that may arise. And under that, we have already studied that when we are talking about an agreement, and in that particular agreement, we are seeing that the agreement has been restricted or prohibited by certain legal conditions that the person who is the employee or who is the party to the contract is not allowed to proceed to the legal agreement in the court of law. But there is a clause which says that even if the party is not allowed to proceed to the court of law, the party is allowed to proceed to the arbitration board. That means instead of proceeding to the court, or instead of going to the court of law, instead of having a legal case at a first glance, the first suggested way to solve the dispute has been preferred as the process of arbitration, which is a major alternative dispute resolution mechanism under the ADR, right? So here in this case, if there is a gateway of arbitration instead of the legal proceedings, then that kind of contract or that kind of agreement is also valid in nature. Clear? Then the next point we have understood savings of the contract to refer questions that have already taken. What it exactly means? That means when the question that has already been arising, the not void if the legal proceeding is prohibited in that particular case. For example, when you are coming to stay in my house as rented, for example, you are coming to me and telling me that ma'am, we want to stay in your house for 1 month or 2 months. हम आपका घर पे रहना चाहते हैं and we actually want to take the rent of your home. Okay. So वहां पे मैं आपको बताती हूँ कि देखो, पहली बात ये है कि घर का हालात सही नहीं है, घर बहुत ही बुरा कंडीशन पे है। अगर आप इस घर में रुकना चाहते हो एंड दिस इज गोइंग टू बी माइट बी रिस्की फॉर यू, ओके। तो उसके बाद भी आप लोग मुझे बोलते हो कि नहीं हमको रहना ही है, तो वहां पे मैं आप लोगों के साथ एक एग्रीमेंट साइन करवा लेती हूँ कि चलो ठीक है, आप लोग यहाँ पे अपने मर्जी से रह रहे हो, इवन इफ गेटिंग इन्फॉर्म्ड दैट स्टेइंग इन दिस हाउस इज टोटली रिस्की फॉर यू। सो ये जानबूझ के अगर आप इस घर में रह रहे हो, देन दिस इज नॉन ऑफ माई बिजनेस एंड इफ एनीथिंग हैपेंस टू यू देन आई एम नॉट रिस्पॉन्सिबल फॉर दिस, ओके। सो इन दैट पर्टिकुलर केस, if any question of the fact or any question of the law that has been arised before, जहां पे ये लॉ का ये फैक्ट का क्वेश्चन पहले से ही आ चुका था, and due to the arising of this particular question, the most important thing is there has been the legal agreement been done that ये particular फैक्ट को लेके, ये स्पेसिफिक फैक्ट जहां पे दोनों पार्टी पहले से ही एग्री हो चुके हैं, उसी को लेके किसी भी तरह का लीगल केस नहीं किया जा सकता है। इन दैट केस the agreement is not void in nature, it is valid in nature, okay। So under exception 1 we have already understood about this arbitration clause. Under the exception 2 we have already understood where the question of the law or question of fact has already been arised, and if that is restraining any kind of the legal agreement, or if that is restraining any kind of the legal provision or legal enforcement, then that is not void in nature. Then the exception 3, it speaks about saving of guarantee agreement of a bank or financial institution. That means here it speaks about little different concept, जहाँ पे हमने ये पढ़ा था, any kind of the bank or financial institution, if that is entering with a contract with any of its customers, that the customer can't raise a question of law in the court of law if there is the matter of repayment, or the bank is taking over the property of the customer or the person who is not unable to repay the amount. Then in that case, that kind of agreement by the bank or financial institution is totally valid in nature, okay। Then we have we are about to discuss section 29 today, which speaks about the agreement is void due to uncertainty, okay। So it speaks that agreements, the meaning of which is not certain or capable of made being certain, are void. So what does it mean? Any kind of the agreement which is not certain or capable of being made certain are void in nature, okay। So first thing, what does it speak? Any kind of the agreement whose nature is totally uncertain, who is indicating any kind of the incident, any kind of the activities which has the uncertain nature. Got it? Or any kind of the agreement or contract which is not capable of being certain in nature, that is void as per se. Okay. For example, we can talk about the illustration, certain kind of illustration we can talk about. A agrees to sell B 100 tons of the oil. There is nothing whatever to show what kind of the oil was intended. So here the agreement is void due to the uncertainty. Uncertainty can be of different time. Uncertainty can be due to the time period. Uncertainty can be due to the nature of the product, and uncertainty can be due to the amount of particular product. फॉर एग्जाम्पल मैं आपके घर पे जाके आपको बोलती हूँ कि मौसी जी आप मुझे 1 लीटर तेल दे, आई वॉन्ट टू बाई 1 लीटर ऑफ द ऑयल फ्रॉम यू. तो आप मुझे आके बोलते हैं कि आप मुझसे 1 लीटर का, मैं आपको जाके बोलती हूँ कि मैं आपसे 1 लीटर का तेल खरीदना चाहती हूँ, राइट? तो वहां पे आई एम नॉट स्पेसिफाइंग एनीथिंग कि व्हाट काइंड ऑफ ऑयल आई वांट टू बाय. Just like, is it a mustard oil, or is it a sunflower oil, or is it a nariyal oil? What kind of oil I want to buy? I have not specified anything particular. So here, in that case, that kind of agreement is totally void in nature. जहां पे आपको सिचुएशन का अनसर्टेनिटी हो, आपको पता नहीं है कि आगे क्या होने वाला है, आपको इस बात का पूरा क्लैरिटी नहीं है कि आप क्या खरीदना चाहते हो, कब खरीदना चाहते हो, कितना अमाउंट का खरीदना चाहते हो, आपको इस चीज का क्लैरिटी नहीं है कि आपको एक्चुअल में चाहिए क्या. सो व्हेन द एग्रीमेंट्स that has been uncertain in nature, they are usually void due to this uncertainty. Clear? Coming to the another example, there is you can see just some other situations like for example, I am telling you that I want to sell you this particular instrument. मान लीजिए this is a gold ring. Okay, मान लीजिए this is a gold ring. I want to sell you this ring. मैं आपको ये रिंग बेचना चाहती हूँ. Okay. So here, when you are coming to me and asking me that, ma'am, can you just sell this particular ring to me? Then मैं वहां पे बोल रही हूँ कि हाँ ठीक है, मुझे रिंग बेचने में कोई दिक्कत नहीं, मैं रिंग बेचना चाहती हूँ. बट वहां पे प्राइस क्या रहेगा आप मुझे पूछते हैं. तो वहां पे क्या मेरा आंसर होता है, मैं बोलता हूँ कि देखिए रिंग का प्राइस आइदर मैं आपको 70,000 में बेचूंगी, नहीं तो 80,000 में बेचूंगी. तो आई एम नॉट स्पेसिफाइंग एनी पर्टिकुलर अमाउंट ओवर हियर. 70,000 या 80,000, कौन सा अमाउंट पे मैं आपको ये रिंग बेच रही हूँ. Am I specifying anything particular कि मेरे को रिंग इतना ग्राम का है, उसका पैसा इतना लगेगा, and that is why I want to sell the ring at this particular price. Am I specifying this? The answer is no. So when there is the agreement which is uncertain in nature, उसका कोई फ्यूचर का सर्टेनिटी नहीं है, उसको पता नहीं है कि एग्रीमेंट आगे जाके क्या होने वाला है, देर इज नो प्रॉपर क्लैरिफिकेशन, उसको ये चीज का समझ नहीं है कि अगर तेल खरीदना है तो कैसा तेल खरीदना है, क्या तेल खरीदना है, राइट? सो दिस थिंग नीड टू बी टेकन केयर ऑफ बिफोर एंटरिंग इनटू ए वैलिड एग्रीमेंट, because these natures of an agreement makes the agreement totally void in nature. Clear? Then comes to section 30, which speaks about the agreements by way of the wager that is void in nature. Okay. So when we are talking about the wagering activity, wagering means just like using the money as bet. Okay, that is specifically called wagering. And we can say that even if wagering is not allowed in India, Even that has been even clearly said that agreement in by the way of Pfizer is void in nature. For example, India Pakistan का match हो रहा है. Some people are waging in on behalf of the India and some on behalf of the Pakistan, right? So waging means टस लगाना, जिसको बोलते हैं कि आप फॉर एग्जाम्पल आप किसी भी तरह का जुआ खेला है कभी, जुआ खेलना, इसको हम इंडिया पे लीगल नहीं मानते हैं जुए खेलने को, राइट? सो दिस इज द एक्टिविटी ऑफ द वेजिंग, जहां पे आप अपना घर को बंधक लगा देते हो, आपका पैसा घर बंधक लगा देते हो. एंड इवन इफ यू नो आवर महाभारत स्टोरी, दिस वेजिंग वाज द main reason of the biggest war in the universe, that was the Mahabharat. You know that very clearly, right? So वहां पे क्या हुआ था, युधिष्ठिर ने अपने ये जो जुआ खेल के अपने सारा चीज खो दिया, इवन एट द एंड उनके पत्नी को भी खो दिया था उन्होंने. So here the activity of the waging, that is totally prohibited in India. Waging is not allowed at all. Got it? So when the point arises, when we are talking about the waging, in that case, it is also spoken, it has been also told that exception in favor of certain prizes of horse racing. What it exactly space? It speaks that when it is the activity of the horse racing, then in that case, this section is not applicable and the money, the bet, the prize that has been announced in the activity of the horse racing, that is not prohibited or illegal in nature. Okay. So here, the next section we are talking about, that is section 31, that speaks about the contingent contract. The contingent means the thing or the particular property which has been continuously changed. Contingent meaning the thing or the person or the property or any kind of instrument which is particularly keep changing, जो हर वक्त बदलता रहता है. So in that case, that kind of contract is called as the contingent contract. Clear? So under section 31 of the Indian Contract Act, when we are talking about the contingent contract, it is a contract to do or not to do something if some event collateral to such contract does or does not happen. That means contingent contract means it indicates a kind of contract which might happen, which might not happen. The validity of the contract totally depends upon an uncertain event which may occur, which may not occur. Got it? So, moreover, coming to the illustration of section 31, it speaks about a contract to pay raise 10,000 if B's house was burned. This is an contingent contract. वहां पे क्या होता है? That means, for example, I am promising you that I will pay you the amount of 50,000 if your house is burned. अगर कल को तुम किसी भी मुसीबत पे जाके फंसते हो, अगर तुम्हारा घर जल जाता है, then in that case I am going to pay you 50,000 rupees and that is my contract to me. Got it? So here the point is the amount I am paying you, the amount of 50,000 I am paying you, that is in return of समथिंग कि अगर आपका घर में कभी भी आग लग जाता है देन, बट अगर नहीं होता है देन यू आर नॉट गोइंग टू बी गेट पेड फॉर दैट पर्टिकुलर मनी, राइट? So here it is clearly said that any kind of the contingent contract that is then applicable when the condition associated to that particular contract is implemented by the court of law. Got it? So here in this kind of the agreement or this kind of the contract, contingent contract, that is valid if the terms and conditions are getting fulfilled and that is invalid if the terms and conditions are not getting fulfilled. Okay. So this was about the section 31 of the Indian Contract Act. Under section 32 till the end of chapter 3, we are going to discuss in the next class. This is all for today, and we are signing of the class over here, because after 10 minutes, after 5 minutes, we are going to start with the class of the Hindu law itself. Thank you so much.